a few questions that kind of goes to the practical aspects of this concept. So when let's say that I have a document I want to claim privilege for, should I put that document, let's say it's a letter, right, that somehow is privileged. Should I still include it in the affidavit of documents and put it under that schedule that says privilege? I think there's a schedule
There is a schedule that says documents that you won't, I don't remember the words, but it says, documents you won't disclose because they're privileged.
Yeah, so I should list it, right?
So what I see
in
my practice,
a
lot of lawyers put emails and communications between counsel and like very vague.
Oh, I see.
Say like email dated, this and that. They say communications between client and counsel, blah, 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 that kind of
I see. Because I was wondering, okay, that's interesting, because I was wondering how can you claim privilege, and at the same time, if you have to put it in the affidavit of documents, you're almost disclosing what it's about.
And maybe that's a good segue into another issue that's very important for people to understand, is waiving privilege.
Oh, okay.
You start talking about documents and you start invoking documents that are privileged. They're not privileged anymore.
Oh, okay. You have to be careful.
You got to be really careful. So one of the ways to make your privilege vanish is to invoke those privileged documents as an issue in the case, right? So let's say, you're being sued because, I don't know, you kicked someone's dog or whatever. And then your defense is, well, I had communications with my lawyer that it's legal to kick a dog, right?
Okay.
So you like invoke this communication that should be privileged as an issue in the case. Like, is that a defense for you? What did those communications say? Are you being, those aren't, it's open now. And what the courts do, and you got to be even more careful, because what the courts do, they don't just say only the emails about the dog are open for business. The whole file. They don't let you pick and choose, right? So once you've opened that door, it's all in, right? So you have to be very careful about how you deal with, invoking issues and information documents that you think are privileged in your case.
Okay, next question. What happens if you've gone through, all the steps, the pre-trial, and then now you're at a trial, and then your opponent used something that you said at a settlement conference against you, even though it's privileged? What happens if they blurt it out or they use it against you? What can you do about that? Can you just say objection? I mean,
that's exactly what you do. So it's good that you mentioned settlement conferences, right? Because settlement conferences are very important events in a case, right? And the court takes them very seriously. So if you're getting ready for a settlement conference, or you've been through one or whatever, that the judge doing the settlement conference cannot be the same judge that's right actually decides the case, because they don't want any of that privileged communication, any of those privileged stuff that you're talking about, offers, this, and things like that, to be in the mind of that the one who's actually deciding the case, because it's supposed to be a secret from them, right? It's privileged. And to that end, if someone starts divulging it, you should object. And you should, and if it's happening before the trial and they're just sending stuff out, a motion might be necessary to have that stuff struck out, right?
But what if they just do it like right in the heat of the hearing, and it just kind of the opponent, they just say, but yes, once the trial judge hears it, it's kind of hard to tell them, forget what you just heard, like,
No, but trial judges, they're good, they're smart people, and they're able to deal with that, right? And first of all, understand how litigation works. And they understand that people, remember, like, there's in settlement discussions, and this is, I think, important for the settlement conference and all that stuff. There's a lot of times people just want to buy their way out of a case, right? And a judge knows that. So if someone in the settlement conference turns around and says, well, in the settlement conference, he was willing to give me $10 million, not only is that like not relevant because it's settlement privileged, sorry, it's not relevant and it's settlement privileged and all that stuff. The judge knows like the motivation behind that could be because the person knows they're going to lose, or it could be just they don't have time, they have vacation booked and they want to get out of here and they're just willing to buy out of the case, right? So I think judges are smart enough and experienced enough to understand how to, push that stuff they might have heard aside.
Okay, that's good to hear. Any last words? I think we're pretty much done.
No, that's it. The only thing I just want to remind everyone, like I said, it's very complicated. Waiving a privilege is very complicated. What you can waive privilege by like explicitly saying I waive my privilege, or you can do it by your conduct. If you send out information that if you didn't realize, well, if I'm sending this out, this might open the door to my whole lawyer's file, right? So it's very important that for your own case you really take a look at what's privileged, what's not, look at your own facts, because in Canada, and if you look at that Sable case, we don't really have classes of privilege. Like we do, but when we really get down to the technicalities, we don't. We have this test that says it's called the Wigmore test, and it says there's 4 parts to it. We don't have to go into detail, but like, should this be privileged in this specific case?
Right.
And so everyone's situation is going to be different. So it's very important that you really figure it out for yourself in your case.
So there's not really anything called sort of absolute privilege, because you have to go down to the sort of fundamental concept, right? Like you said, you have to go down to first principles to decide whether something should be privileged.
Well, and the judge will decide, so they might not even decide their thoughts, right? So I mean, there's some really clear rules, but there's always exceptions, and there's always, like I said, the waiving of privilege always messes things up and stuff like that. But yeah, I think for the most part, just remember, and this is what I see with self-reps a lot, is that anything said in a settlement conference, you can't say it anywhere else. And anything sent around for settlement purposes, save it until cost time.
And of course, you should not be disclosing the other side's stuff as well, like, because when
no, that'll get you in trouble, because that's privileged. Right.
Okay, well, thanks, Dan, for your helpful explanation on this. This is interesting, and thanks everyone for watching. And we're going to see you in the next video.